Hi guys, it is March 11 and the almighty UK has finally implemented their no dependence rule. Okay, I know this is not shocking because we've been speaking about this a long time ago, but however, a lot of people are confused and they want to find out if they're affected or not, especially if you've been here on a separate visa that is not health and care visa. Maybe you're on a student visa and then you want to now switch with your dependents on a care visa after March 11. Will you be affected? I know you have these questions. Some questions that I also received in my DM were people asking me that, oh, what happens if I am probably on a separate visa and then I've put in my application before March 11 for health and care visa? Will I be affected? And so on and so forth. I promise you this video is going to be very detailed, very concise, and I will give you every explanation to any possible question that you might have. So you want to stay tuned to this video and you want to watch till the very end. Hi guys, my name is Yeti and welcome to another episode of Yettysplash. If you're seeing my face for the first time, you're welcome. On this channel, I share information about relocating to the United Kingdom, everything UK, everything abroad, ultimately settling abroad. Okay, so if you haven't subscribed yet, please do well to click the subscribe button, like, share, and keep following Yettysplash across all my social media handles. So let's get straight into today's video. Let's get straight into it. The very first thing I'm discussing is the tweets. Okay, that's the foundation of all of this. On the March 11, 2024, the Home Office tweeted, "From today, care workers entering the UK on health and care visa will no longer bring dependents. This is part of our plan to deliver the biggest ever cut in migration." And then you see that picture, banned. Oversee care workers from bringing dependents. So it is clear, there's no doubt. If you're just coming newly to the UK as a care worker, you cannot bring independence. So a lot of people are confused. When you say care worker, what do they mean? Do they mean that everybody in the health and care sector? Or what exactly are they talking about? So I'm also going to be reading out another regulation for us to clarify that, okay? And I'm going to leave the link to everything in my description box so you can also click on it to follow up and also read for yourself. And also I'd like to say that I'm not an immigration advisor, but everything I share is out of my in-depth research, okay? You have to also do your own in-depth research before you come to a conclusion. But everything I'm sharing with you today, I've researched it completely, understood it in and out, and also my legal background, I've been able to use it to interpret it. That is why I'm sharing it with you today. So I'm going to be showing you this document that will further answer those that are classified as care workers and those that will be affected by this new law in the UK. So guys, I have the documents with me now. It is titled Health and Care Visa Guidance Accessible Version. It was updated 11th of March 2024. Okay, it is very recent. It was just updated 11th of March 2024. Now it talks about health and care visa in general. If you look at this document, and I'm reading particularly from number 3, right? The health and care visa would apply to the following list of standard occupational classification code. So if you're seeing the code on my screen now, that is 1181, Health Services and Public Health Managers and Director 1242. There are a host of occupations and their lists. All these lists that you can see, all this SOC code is applicable. They're all classified as health and care workers, okay? So if you are a medical radiographer, that is 2217, you are also an health and care worker. If you're nurses, midwives, social workers, 2422, laboratory technicians, paramedics, and so on and so forth. You see, from the beginning of that of 1181 code to the last end on this list, which is 6146, senior care workers, they are all classified as health and care workers. So this now begs to ask, are all these people exempted, or are all practitioners in this code exempted from bringing independence? Are we saying that everybody on this list that have been, classified as health and care worker now, are they all stopped from bringing dependents to the UK? The answer is no, guys, capital letter NO. So not all occupation listed under health and care visa that are restricted from bringing independence, okay? So we're now going to check those that would actually be affected. What occupation are we talking about? Who are those that cannot bring independence from March 11, 2024? So let's look at this. Number 10 of this particular regulation that we are still reading states that if you submit your health and care visa application from 11th of March 2024 with care certificate of sponsorship for 6145, that is care workers and home carers, or 6146, senior care workers, you will be unable to include your partner or dependents in your visa to come to or stay in the UK. That is it, guys. So they are saying clearly here that only carers and senior carers. So if you're on any other kind of health and care visa, if you're a radiographer, if you're a nurse, you're a midwife, you're not affected. Though you're an health and care worker, but you can still bring in dependents. Only those whose sponsorship code is 6145 and 6146, that is carers and senior carers, that would be affected, okay? And then they further went to state that this restriction will not apply to skilled worker on health and care visa holders with visas issued for applications submitted before 11th March 2024, or if the dependent is a child born in the UK. So that's the exemption. The exemption is that if your visa was issued before March 11, 2024, or you put in an application for March 11, 2024, then you're fine. You can bring in dependent. But if it is after March 11, 2024, you can no longer bring in dependent. And if you have a child born in the UK, then that child can apply with you. But we're going to look into details. We're going to look into that in details, okay? So moving on again, this health and care visa guidance also talks about the eligibility requirements for health and care visa for carers and senior carers. So if you check paragraph 4, it says that in addition to the requirements set out in the guidance, applicants for health and care visa will need to meet all relevant criteria for a skilled worker. These requirements are set out in immigration rules at Appendix Skilled Workers and Appendix Skilled Occupations, including 1. A requirement for applicants to work for a UK employer that has been approved by the Home Office. So before you can get an health and care visa, you have to work for a UK employer that has been approved by the Home Office. Then they further stated that applicants with certificate of sponsorship for occupation codes 6145, that is care workers and home carers, and 6146, that is senior carers, must work for a CQC regulated employer. So if you want to be sponsored now on an health and care visa from Nigeria, it's not just any care firm. That care firm must work for a CQC regulated employer. Where an applicant has already been issued a visa to work for an employer which is not registered with the CQC, under the rules in place before 11th of March 2024, they can extend their permission with the same employer. So if you're already working for a care firm that is not regulated by the CQC, you're not affected, you can extend your permission with them. But if you're now looking for a new carer, maybe they gave you 3 years visa and your visa is over, you want to apply for 2 more to make it 5 years in the UK, or probably you want to switch care firms, but you must ensure that the next one you're switching to must be CQC regulated. That is, if the first one you're working with was not CQC regulated. So if you're with a firm that is not CQC regulated, you can stay with them, you can extend your stay with them, but as long as you're moving on from them to another firm, then you must stay compliant. You must look for a firm that is CQC regulated, and yes, you can move with your dependents. Now we want to check in details exactly those that will be affected and those that would not be affected. So guys, the last document we are going to be looking at to make everything make sense for this video is what we call the Dependent Family Members in Work Route. This document is by the Home Office, and this document is the final document that explained everything. Like, it shed more light to the situation, all the possible questions you could have. They explained everything in total, and that's what we're going to be looking at, okay? So the document has 38 pages, but we're going straight to the one that relates to us, and that can be found on page 8. So once you just Google the title that I've given you earlier on, you can just go straight to page 8, and also I'll leave the link to it in my description box for those that want to access it. So I hope you can see this now. It says that care workers and senior care workers. So this document deals with dependents and all explanation. Now this is the explanation for dependents of care workers and senior carers. Unless one of the exemptions below apply, the applicants must not be applying as the partner or child of a skilled worker who is sponsored for a job in the occupation code 6145, care workers and home carers, or 6146, senior care workers. So that first line says that unless some exemption apply, these carers and senior carers can no longer bring in dependents to the UK. So what are these exemptions that will allow you to either bring dependent or remain with dependents in the UK? Next paragraph. If the lead applicant has continuously had permission as a skilled worker, accepting that any gap subject to paragraph 39A can be disregarded under the rules in force before 11 March 2024, sponsored in either or both this occupation code, that is 6145 or 6146, a dependent may apply. So they are saying that as long as the main applicant has their visa. They've been sponsored on either as a carer or senior carer before March 11, 2024, then your dependent can apply. You can bring in dependents even if they are not in the country yet. You can apply for them. They can always remain with you, either if they're in the country or you're just bringing them in. So to be eligible for this exemption, lead applicant's original application dates must have been before March 11, 2024, even if the application was granted after March 11, and whether or not their dependents applied at the same time. So it doesn't matter whether you apply with your dependent or you did not apply with your dependent. As long as you have submitted an application before March 11, 2024, then you are free to apply for your dependent later on, even if they did not apply with you. Now, the other exemption part has to do with child born in the UK. I've already made an extensive video about this. You can go back, check my videos and watch it. I'll put the link in the description box. It's very, very educative. You have to watch it. But this exemption is that if you have a child born in the UK, then they can apply as your dependent. So if you're on a previous visa before, maybe you're on a student visa, and then you now later switch to health and care visa, you will not be able to switch with your dependent. But if you now give birth to a child in the UK, then you can apply for that child to remain in the UK as your dependent. So you see, the child is not already citizen yet. So they're already giving them preference because they were born in the UK. This is just like a benefit of a child born in the UK and the one that is not, that you didn't give birth to in the UK. But yeah, that is that. Let's go on to the examples that they've listed, and I'll also explain the child further before the end of this video. So now, examples. Migrant A has been sponsored as a care worker with their partner and child since 10 January 2022. Their dependent can continue to apply as such. So if you've been in the UK before March 11, 2022, you've been on an health and care visa before then you can apply and remain with your dependent. That is what example A is all about. So if you have been sponsored as a migrant, as a care worker with your partner and child since January 2022, then your dependent can apply and stay with them. Okay, that is one. Migrant B has been sponsored as a care worker since 25th of November 2023, but had not applied for their partner or children. They can make an application for their partner to join them at any time during their period of leave. Okay, this is scenario 2 now. If you're in the UK on an health and care visa and you've been on this visa before March 11, 2022, then you can always bring in your dependents, even if you never applied for them before. Even if they're in Nigeria, if they're in Ghana, if they're in any part of the world, you can apply for them to remain or to come and meet you in the United Kingdom. Okay, that's what example 2 is all about. So those people, they will not be affected. Now, Migrant C has been sponsored as a nursing auxiliary since 10 July 2023, but switches to being a senior care worker with an application made on 15 March 2024. Their dependents will not be allowed to make applications in connection with their leave as a senior care worker. So now this is where it gets real, right? This is where it absolutely gets real. So what they are saying is that if you're in the UK on any other kind of visa, maybe you're on a student visa, you're on another kind of skilled worker visa, you're a nursing auxiliary, you're a social worker, any other kind of visa that you are on, as long as you want to switch your visa and you are switching to health and care visa after March 11, 2024, then your dependents will not be able to remain. So this is also where children who are born in the UK applies. Because let's say, for example, you're here with your family now, your husband and then your child as well. They will not be able to switch with you if you are on a separate visa. Maybe you're on a nursing associate kind of visa and the SOC code was not health and care before, and you now want to switch to become a senior carer. You'll not be able to remain with your dependent and your dependent child. But if your child was born in the UK, then you can remain with them. They can apply to remain with you in the UK. I hope this is very clear enough. Please hit the subscribe button as I'm painstakingly making all this explanation. The only thing you can do for me is to subscribe. Thank you. Love you guys. So moving on. Migrant D has been a student since 1st of September 2021. They switches to being a care worker, having completed their course with an application made 1st April 2024. Their dependents will not be allowed to make application in connection with their leave as a care worker. So this one is very clear. This is for students. If you're a student in the UK, you can no longer switch to a care worker and then bring in your dependent. So this is my advice. If you're a student, just apply for a post-study work visa gently, and while you and your partner keep trying for all that kind of skilled worker visa. But if it is health and care, based on this example of Migrant D, you cannot remain in the UK with your dependents at all. Migrant E now. Migrant E has been sponsored as a care worker since 1st June 2023, but switches to being a senior care worker with an application made 25th March 2024, their dependent can make an application. So this means that you are already in the UK on a care worker, you now become a senior carer, you can still move in with your dependent, because 6145 and 6146 is still the same code affected. So as long as you have your health and care visa with you before March 11, if you switch, if you extend, as long as you're switching to the same, SOC code, you can still remain with your dependents. Okay, so that one is really straightforward. Migrant F switches from being the dependent partner of a student to being a senior care worker with an application made by 10 March 2024. Their partner can apply as their dependent subject to the course completion requirement. Okay, so this is for those that maybe they have a partner in the UK now. You are a dependent to the main applicant. If the dependent to the main applicant gets this health and care visa before March 11, that is at least by 10, you've already put in your application. Then anytime your main applicant finishes their studies, because we all know that if you're in the UK now on a student visa, you cannot switch to any other kind of visa until you have finished your course. So if that person now finishes or her course, anytime they finish, they can always come and join you as your dependent on your own health and care visa. That is because you made the application by 10th March 2024. So you made it before the 11th of March cutoff date, so that is really straightforward as well. Dependents who have already switched to health and care visa can then still remain in the UK, while their applicants can apply to join them anytime they finish their course. So these are the various scenarios. I hope this clarifies everything. Check my description box, I will put it there. You can also book a one-to-one consultation with me if you require for that clarification, but I think I've been able to do justice to this topic. Let me know what you think. Honest feedback in this comment section would be appreciated. But please don't forget to subscribe. It is really important that you subscribe, you like it, you share it as well. Share this video with your friends and families that would probably that are having doubt or need to be clarified. And then if you're still unable to get clarity, then you can book a one-on-one session with me to clarify, or you ask your questions freely in the comment section where I will be providing answer. Thank you so much for joining me. Thank you for watching till this very end. I love you guys so much and stay blessed. Bye guys.